morning everyone, I'm a reporter from Channel 4. In today's special report, we will bring you to the front line of justice, or some might call it the Men Don't Get Raped hotline.
Hello? Apalah, cik sedang busy ni.
I would like to report a rape.
You ke bang?
Yes.
Kejap.
Okay, thank you. Good morning, everyone. Today, we're diving into a truth that's been hiding in plain sight: male sexual assault. When we hear the word rape, many instinctively picture a man as the perpetrator and a woman as the victim. And that's just not social bias, that's the law talking. In Malaysia, our penal code, specifically section 375, defines rape as a man having sexual intercourse with a woman under certain coercive or non-consensual conditions. So, what happens when a man is raped? Legally, he doesn't fit the definition. Emotionally, he suffers from the same trauma. Systematically, he hits a brick wall. Take the case of PP and Muhammad Fadli bin Abdul Rahman in 2012. Here, a man forcibly penetrated another man without consent. He was charged under Section 377C, not rape, because our law doesn't recognize male rape victims. The act was the same, the trauma identical, but the charge categorically different. That's where we start to see how dangerously outdated this is. Section 377C criminalizes what it calls carnal intercourse against the order of nature without consent. But let's be real, that sounds less like a serious offense and more like something out of a Victorian insult book. It's vague, stigmatizing, and more importantly, it's not rape. So, when a man is assaulted by another man, or even by a woman, the law calls it something else, something legally and socially lesser. Even worse, when the victim is under 18, the Sexual Offences Against Children Act 2017 steps in. It's gender neutral, thankfully. But once he turns 18, the law hands him a birthday card and walks away. Take the case of PP and Jeffrey bin Mohammed Jeffrey 2014. A male minor was sexually assaulted. The perpetrator was convicted, but again, not for rape. Because, in the eyes of the law, rape stops being rape when the victim is a male and turns 18. Moving on, this gap in our legal framework isn't just a crack, it's a chasm. Adult male rape victims are either miscategorized, ignored, or funneled into legal boxes that don't match their trauma. And the impact? Many never come forward. Those who do rarely get justice. If the goal of the law is to protect people, not just categories, then it must reflect the realities of all victims, not just the ones that fit neatly into Section 375. Even the United Nations CEDAW Committee, in General Recommendation 35, has called for gender inclusive protection against sexual violence. Malaysia, right now, isn't just behind, it's failing some of its most vulnerable. It's time to rethink what justice looks like and who it's really for. Next, Charmaine will be explaining further on this topic. Thank you.
Thank you for looking into Malaysia's legal landscape. Now let's shift gear and fly over England and Wales, where the legal system is proud to say everyone is equal under the law, with one very specific and rather awkward exception. Under the Sexual Offences Act 2003, Section 1 to be exact, rape is defined as a person commit an offences if he intentionally penetrated the vaginal, anus, or mouth of another person, B does not consent to the penetration, and A does not reasonably believe that B consented. That's right. According to this definition, you literally need a penis to be a rapist, which means that, yes, the victim can be anyone regardless of gender, but the penetrator, always legally male. Now, before we all spiral into legal existentialism, let's clarify. Victim can be of any gender, and yes, men can be raped. The law does provide some backup with assault by penetration under Section 2 for cases involving objects or non-penal body parts. Same maximum sentence, different labels, because calling everything rape will be too simple, apparently. But wait, there's more. Section 3 handles sexual assault, which covers, get this, cases where a man is forced to penetrate a woman. The sentence cap just 10 years, which kind of says, hey, this is bad, but not as bad. Justice may be blind, but she's definitely squinting. Let's talk case law. Yes, the fun part. In R.M. McNally, the court ruled that lying about your gender can invalidate consent, a landmark moment of the recognizing how consent works across gender lines. Then there's DPP and Revit, which might sound less dramatic, but it confirmed that legal safeguards and guilty pleas must be taken seriously, no matter who the victim or the accused is. It's about consistency, something the law desperately needs more of. Ireland followed the suit in the People and Maher, knocking down the sentencing disparities based on victim gender. It's like the UK's cousins are evolving faster than it is. Now, let us address the elephant in the courtroom. The societal myth that men can't be raped. This is idea doesn't just live in whisper. It's baked into how police handle case, how juries preserve victims, and how many men suffer in silence. This damaging bias means male team often don't report what's happened to them, and when they do, the risk being doubted, laughed at, or ignored, especially if the penetrator is female. The very system meant to protect them is often the one that lets them down. Even within the courtroom, male victim may not be believed, not because of the evidence is there, but because of the narrative doesn't fit. This is not just a social issue, it's a structural one. Now, from a human rights standpoint, the UK should be better. Article 3 of the European Convention of Human Rights prohibits inhuman or degrading treatment for everyone. And the Equality Act 2010 prohibits discrimination based on sex. A recent UK Supreme Court decision for Women Scotland lead and Scottish minister in 2025 clarified that legal definition in policy and law must not exclude victim based on gender. The ruling reminded lawmakers inclusive isn't optional. So, while England and Wales have taken steps forwards with gender neutral wording in some areas, that one requirement, penal penetration, it still holds us back. Let's pass it over to the next segment where we critically analyze the needs for legal reform in Malaysia. Thank you.
Good morning, everyone. We are reporters from Channel 4.
Today we're here with the man who almost became a victim, but by law he isn't. Excuse me, sir. Excuse me. Do you have some time for us?
What?
So tell me, how does it feel to receive this?
It's like a participation award for existing.
Back to you in the studio. Thank you.
Thank you. Malaysia's international treaty obligations require it to align its domestic law with global standards on gender and sexual violence. First, under CEDAW, Malaysia pledged to eliminate discrimination in all spheres, Article 2. Yet it still maintains reservation to Article 16 on family law and inheritance and its penal code gender-specific rape definition, Section 375, which undermines both Article 2's equality mandate and Article 5's call to end harmful stereotypes. In 2018, the UN CEDAW Committee pressed Malaysia to adopt a gender-neutral rape law with penalties proportionate to harm. Similarly, the CRC, which was also ratified in 1995, obliges Malaysia to shield every child from sexual abuse, Article 34. But a 2022 case in Kedah showed that without a gender-neutral rape statute, a 15-year-old boy's assault by an adult woman was prosecuted merely as outraging modesty under Section 354, falling short of CRC's protections. Although Malaysia has signed but not ratified the ICCPR, it remains bound by customary norms outlawing torture and inhumane treatment, which encompasses sexual violence, Article 7, and requires effective legal remedies, Article 2, subsection 1. In 2018, ratification of the CAT reinforces this duty, demanding comprehensive criminalization of gender-based violence, Article 16. And finally, during its 2018 Universal Periodic Review, Malaysia agreed to review sexual offense laws, yet no gender-neutral reforms have reached Parliament. Regionally, the 2012 ASEAN Human Rights Declaration and the 1993 UN Declaration for Health, Well-being, and the criminalization of all forms of sexual violence standards Malaysia has yet to fully meet. Now, let's talk about why gender-neutral reform is urgent. Constitutional equality, Article 8. Malaysia's own federal constitution guarantees equal protection of the law. A law that literally names a man and a woman denies equal protection to transgender, non-binary, and male victims. Judicial clarity and sentencing party. Sections 354 and 377C carry lower max sentences and leave prosecutors and judges guessing on consent standards. A single gender-neutral rape provision up to 20 years imprisonment would align. Over 120 jurisdictions now define rape without referencing to the perpetrator's or victim's gender, focusing on the lack of consent as a sole element. As long as Section 375 remains in its current form, Malaysia stands at odds with international human rights obligations if it is voluntarily assumed and with its own constitutional promises of equality. Reform is not just policy, it's a treaty-bound duty.
Thank you, Tanuja. Building on that, I will present the arguments in favor of legal reform. Malaysian law urgently needs a gender-neutral rape statute. Central is legal equality. Article 8, Clause 1 of the Federal Constitution declares that all persons are equal before the law and entitled to the equal protection of the law. Yet Section 375 still defines rape only as a man having sexual intercourse with a woman. In practice, this means male survivors cannot be legally raped and female rapists go unpunished. Criminal lawyer Watsuan Pillai warns that under current law, only males can rape and only females can be victims of rape. This type of gender bias contradicts Article 8's promise of equal protection. Today, Malaysia has two overlapping offences, Section 375, which is male and female vagina rape, and Section 377C, that is carnal intercourse against the order of nature, used for anal or oral cases of any gender. When a man is raped, the case is typically investigated under Section 377C, a colonial-era sodomy law, not a rape law. A single gender-neutral rape provision will streamline cases and focus on the act and consent. In the local context, the need for reform is urgent. Official police data show male sexual assault reports jumped 64% from 2021 to 2023. Filmmakers and advocates know the stubborn stigma. Many Malaysians still believe boys can be raped and boys don't cry. The law should serve to protect victims. As a comparison, in England and Wales, the UK Sexual Offences Act 2003 offers a modern template. Under this law, Section 1 defines rape as the penetration of the vagina, anus, or mouth by a penis without consent. Crucially, this applies equally whether the victim is male, female, or non-binary. Complementing this, Section 2, which describes assault by penetration, covers all other non-consensual penetration of the vagina or anus. Both offences ensures female perpetrators or male victims are sentenced and treated as seriously as Section 1 rape. Hence, Malaysia can redefine Section 375 in gender-neutral terms to be whoever intentionally penetrates another person's vagina, anus, or mouth with any part of their body or an object without consent commits rape. A parallel assault by penetration offence could cover other acts, just as in the SOA 2003, whereas Section 377C should be repealed. This would modernize Malaysian law in line with international best practice. Some may fear gender-neutral laws clash with Malaysia's cultural norms, but law reform need not endorse lifestyles. It simply acknowledges the reality that sexual violence happens to all genders. So as a conclusion, Malaysia's rape laws are anchored in an outdated, gendered understanding of sexual violence. Reform is not merely a legal technicality. It is indeed a moral imperative. The time for reform is undeniably now. Thank you.
Beyond reforms, institutional charges are necessary to support
and protect male survivors of sexual violence. Law enforcement agencies, including the Royal Malaysian Police, require specialized training to handle such cases with sensitivity and professionalism. Police officers, prosecutors, and judges should receive gender sensitive and trauma informed training to understand the unique psychological and societal dynamics faced by male victims. Standard operating procedures, also known as SOPs, should be explicitly established for handling male sexual assault cases, including guidelines for medical examination, evidence collection, and psychological support. From a social standpoint, a significant barrier to justice for male victims is the stigma and the belief surrounding the notion that men can be sexually assaulted. Public education and awareness campaigns are vital to dismantling harmful myths such as belief that men cannot be raped or physical arousal equates to consent. These campaigns should target schools, workplaces, and communities and include messaging that emphasizes consent, boundaries, and respect for bodily autonomy. In addition to legal and educational reforms, the government should invest in survivor support services that explicitly include male victims. This provides funding for shelters, hotlines, medical services, and counseling centers is tailored to male experiences of trauma. Collaborating with NGOs and civil society organizations already working in this area can ensure real world experiences and best practices inform these services. Furthermore, data collection must be improved. Government bodies should be required to collect and publish gender disaggregated data on sexual violence, which will be essential for tracking trends, allocating resources, and informing future policy decisions. Finally, these reforms must align with international human rights obligations. Malaysia, as a signatory to the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, is encouraged to ensure that protections against sexual violence are inclusive and non-discriminatory, incorporating global best practices such as those outlined in Yogyakarta Principles on Gender Identity and Sexual Orientation, would also support a more equitable and rights-based approach to lawmaking in Malaysia. In conclusion, the rising incidence of male sexual assaults in Malaysia exposes deep flaws in our legal and societal system, flaws that deny many survivors the recognition, justice, and support they deserve. Reforming the law to adopt a gender-inclusive consent-based definition of rape is not simply a matter of legislative adjustment. It is a crucial step toward acknowledging the lived realities of all victims. True justice demands that protection under the law be equal, regardless of gender. At that same time, we must challenge the harmful cultural myths that silence male survivors and prevent them from seeking help. A reform framework rooted in empathy, equality, and human dignity will move Malaysia closer to a legal system that protects every individual's right to safety, bodily autonomy, and healing.
Goodbye for now.